Hello, I'm Mike Chinoy. I'm the author of the new book, Are You With Me, Kevin Boyle and the Rise of the Human Rights Movement. Joining me today is one of the people who was a very important source for me for the book, and also somebody who's an important character in the book, and that's Michael O'Boyle. Michael's from Northern Ireland. He studied with Kevin Boyle at Queen's University in the 70s, was a lawyer and had a long and distinguished career at the European Commission and Court of Human Rights. I should mention that Michael's in Strasbourg, where he lives, and I'm in Hong Kong, and we're doing this remotely because the coronavirus outbreak has made it impossible to do these sorts of book events in person. In any case, Michael, I wanted to start by just asking you, give me your sense, you knew Kevin for many years, of sort of what he was like and what his idea was of how to use the law as a tool to effect social change and achieve justice.
Right. Well, I mean, I knew Kevin since the early 70s, when I was his pupil attending his criminal law class at Queen's University in Belfast. And obviously, I see Kevin through rose-tinted glasses. A very warm-hearted person with a terrific interest in law and politics and the interaction between both. He had a strong belief that law was not something that was merely academic, to be learnt by rote from textbooks, but something that should be put into practice. And I think that idea lay at the basis of his action and career for the rest of his life.
He was involved, and I write in the book about a number of very important and often quite dramatic cases that he brought before the European Commission and European Court of Human Rights. And since you worked there for a long time, you kind of had a ringside seat for some of them. And I just want to go through a few of them because I think it's really interesting and people will find it fascinating. The first one was the Donnelly case, which involved 7 men who had been badly treated, beaten, tortured in detention by the security forces in Northern Ireland. And that is considered in some ways a groundbreaking case. So give us the kind of layman's version of what's important about that case and what was Kevin's kind of new and creative thinking about law that we saw in that case.
The case was about torture and inhuman and degrading treatment in respect of men who had been detained during the internment swoop in Northern Ireland in 1971. So it was a high-profile case that accused the United Kingdom government before an international tribunal of having infringed one of the most important provisions in the European Convention on Human Rights. Its primary contribution to human rights law probably lies in the development of a notion of an administrative practice. This is a relatively straightforward term, but what it essentially means is that the tribunal can look not only at the acts of inhuman and degrading treatment complained of, but also at the bigger picture, at whether those acts form part of a general practice that existed in the community at large, and whether the authorities were conniving in the commission of those acts, or whether they turned a blind eye to the acts, and as a result of their connivance, rendered any domestic remedies that might exist inadequate and ineffective.
And this was a kind of innovative new way to think about approaching this question.
Yeah, of course it is, because here courts are usually concerned with the people in front of them and the case that they bring. Donnelly created the possibility, and one that was accepted by the Commission, of looking at the wider picture, of saying not only was Mr. Donnelly the subject of inhuman and degrading treatment, but this is a reflection of a much bigger story, a practice that is tolerated at the highest levels of the state. So the theoretical basis of that concept was laid in Donnelly, although, as you know, for technical reasons, Donnelly was eventually rejected. Essentially, the Commission took the view that it would have been open to raise some of these issues before the Northern Ireland courts. But of course, they could never raise before the Northern Ireland courts the wider question.
Right. So this laid the groundwork, in a sense, for other cases that followed. So it was an important contribution in just the way people think about dealing with
very much so. And the baton was taken up by the Irish government in the interstate case between Ireland and the United Kingdom about torture in Northern Ireland. And an important plank in their case was the existence of an administrative practice. And so that concept was then the subject of elaboration and elucidation by the then Commission in an extensive treatment.
Another interesting and groundbreaking case was the Dudgeon case, which led to the decriminalization of homosexuality in Northern Ireland. And here too, Kevin was kind of the guy who devised the approach that ultimately won the day.
Indeed. Kevin was behind the driving force behind the Dudgeon case, along with a local lawyer and friend of Kevin, Francis Keenan, whom you also mentioned in the book. But his idea was that it ought to be possible to get the Commission to look at this case, because the law in Northern Ireland, and indeed in the Republic of Ireland, was totally out of step with law reform that had occurred in most other European countries. So his argument was that once the Commission got to look at the swingeing effect on private life that such a prohibition entailed, that they would be sympathetic. And so it was. I mean, I can remember I was in Strasbourg at that time, and I sat and listened to Kevin pleading the case, along with a later companion of Kevin's, companion in arms, Françoise Hampson. And the first thing that struck us as we looked into the in-camera hearing before the Commission was the inequality of arms between the applicant's side and the government side. Here you had, on the one hand, Kevin and Francis Keenan, and on the other hand, a whole battery of top-flight lawyers representing all the government interests involved in the issue. And notwithstanding that, he then proceeded to, as a result of good argument and good presentation, getting the case declared admissible. And the case was eventually sent to the court, although at that stage, rather unfairly, he was dropped by Dudgeon as counsel. Dudgeon preferred to politicize the whole issue, and he handed the representation of his case over to the then burgeoning Gay Rights Association.
But the foundation, the legal arguments were essentially Kevin.
The foundational arguments were made and accepted by the Commission by Kevin, no doubt. And that case has gone on to become probably the most important precedent in international human rights law as far as LGBT rights are concerned.
One of the fascinating things that I stumbled on in my research was an episode in which you played a part, which is Kevin's effort to, again, with the help of Francis Keenan, to try to use the Strasbourg machinery as a way to mediate during the IRA hunger strike of 1981, which in which 10 men starved to death. There was widespread violence on the streets. It was a bitter standoff between the IRA on the one hand and British Prime Minister Margaret Thatcher on the other. And Kevin tried to see if there was a way to use Strasbourg to find a way to get the two sides to talk. Tell me a little bit about that.
Well, this relates to the hunger strikes, which created an extraordinarily tense atmosphere in Ireland, the south of Ireland, and also in the United Kingdom, because of its implications. Young men were sacrificing their lives for what they considered to be a greater cause, and ramping up the violence and the social and political tension which was already at a fairly high notch in Northern Ireland. So it was an extremely difficult moment. And one of the problems was that there was no discussion. Margaret Thatcher had decided that the prisoners were wrong. They were seeking to bring the struggle into the prisons. And so there was no question of entering into a discussion with them. And as a result, the whole situation festered. One person died and then another person died, and the whole thing became a total catastrophe. Kevin was involved in a case called McFeely, which raised the issue of prison conditions as a result of the dirty strike connected with the hunger strike.
McFeely, just to interrupt, was a prisoner who went on the first IRA hunger strike in 1980, which was called off. And my understanding is that case was largely rejected by the European Commission, but a couple of elements were held sort of in abeyance. And when the second deadly IRA hunger strike started, he was able to get it revived and tried to use that as a way to get negotiations started.
That's correct. McFeely called off his hunger strike, and it was a great personal triumph for Francis Keenan, who was then dealing with him at the time. Because of the application, he accepted the argument that he should give up his hunger strike and place his trust in the Strasbourg process. But when the main strike started, Kevin devised this notion that the remaining complaints, which concerned censorship of prisoners' correspondence, essentially, and the lack of an effective remedy before the local courts for the subject matter of their complaint. But Kevin's idea was that through the friendly settlement procedure of the convention, that he could draw in the government and use that whole process as a vehicle for raising legitimate political and social concerns concerning the damage that the hunger strike was doing and the common interest that all the parties had in bringing that sorry situation to an end. The commission was interested to a certain extent. At the beginning, the government was also interested and attended a closed meeting in Strasbourg, but eventually, sorry to say, Mrs. Thatcher, when she heard about these meetings, pulled the plug on them and gave the civil servants who took part in them a serious telling off.
But it's an interesting example of sort of Kevin Boyle's creativity in seeing the law as something more than just a mere technicality. And of course, he thought, is my understanding, that if you could find a negotiated way out, it would reduce support for the violence of the provisional IRA, which he abhorred. So that was indeed a big setback, and he spoke about that at the time. I want to ask you a couple of other cases. One, freedom of press, freedom of information was a big cause for Kevin Boyle. And there were a number of cases that came to Strasbourg. One in particular was called the Jersild case, involving a Danish journalist who was convicted for reporting about neo-Nazi skinhead gangs. What was the importance of that case in terms of establishing protections for journalists in international law?
Right. Kevin was very attached to the notion of freedom of expression. And it's commonly stated that freedom of expression is one of the cornerstones in any democratic system. And Kevin truly believed that. And indeed was one of the founding, was the first secretary to Article 19, an NGO that was set up to promote freedom of expression throughout the world. So he took on the Jersild case because he considered that there was a fundamental principle at stake. And the principle is this: if a journalist invites a neo-Nazi onto a serious program so that they can see that in their society there are segments that hold these views and espouse to them, whether it's acceptable from the standpoint of freedom of expression that the journalist be subject to criminal prosecution for playing a role in the dissemination of those views. So you can see that that's a fundamental issue for journalists throughout the world. And the court, in a landmark judgment, found that it was in the public interest that journalists exercise this role. They were, if you please, public watchdogs. And it was something that was extremely important for all democracies, that these elements in their society be given an airing so that we can all see that they exist and try and do something about it.
Right. And that the journalist couldn't be held legally liable for noxious opinions which the journalist simply reported as a journalist.
No confusion between the message and the messenger.
Right, right. The other area that I want to ask you about is Kevin's role in bringing cases on behalf of the Kurds of southeastern Turkey to the European Commission and Court in the 1990s. There are too many cases to go into all of them, but give me a sense of how important those cases were, both in the specifics for the people who he represented, along with particularly working with his colleague Francois Hampson and a couple of other lawyers, but also, again, in terms of the kinds of decisions and legal precedents that were resulted from those cases.
There are so many cases that they brought. Like we don't have time to go into all of them, and in fact, I think it must be more than 30 cases. But they involved extremely important issues such as torture, inhuman and degrading treatment, the destruction of property, the disappearances, the failure to carry out effective investigations when Kurds got shot in the street or when newspaper editors got shot. So here we're dealing with human rights at its most basic and most primal level. And all of these judgments, a lot of these judgments were successful. They were generally preceded by a fact-finding investigation, which involved the members of the commission going to Turkey, along with Kevin and Francois, and hearing witnesses. And there was a frenzied activity on fact-finding during that period. And it's regarded with a certain amount of nostalgia by people who work in the court today, because the court is so busy today that fact-finding is simply not possible. Mm. But of course, when one looks at the accumulated effect of these cases, you have important precedents in the area of domestic remedies. Under what circumstances is an applicant absolved from using effective remedies? In a famous case that Kevin and Francois litigated, a case called Activar, they argued that remedies existed, but they were purely theoretical because the applicant's lawyers had been threatened by the executive. And the applicants themselves had been threatened. And so they simply weren't open to them. And the court then went on to find that they had suffered burning of their property.
So these are cumulatively, getting the court to expand the range of options for people suffering from state-sanctioned violence, oppression, rape, torture, and so on, to seek justice. And
they were providing a remedy for these people who otherwise were forgotten. Right. Nobody was interested in what was happening to the Turkish Kurds in the 1980s and the 1990s. No one. Right. And so Kevin and Francois secured a remedy in most of these cases, I would say. But more importantly, they revealed to the Turks and to the rest of the convention community of nations the very serious human rights difficulties that existed in Turkey. You must remember that at this period, Turkey was trying to get into the European Union. And so these cases were studied very carefully in Brussels. And they in turn made it clear to the Turks that they had a lot of work to do to clean their act up. And so the cases inevitably gave rise to rather serious improvements in the criminal code. I would say that at that time, the cases were instrumental in abolishing torture in prison stations. That's where the real problem lay. To a certain extent, this may not have survived, but at the time, these types of cases dried up. And it was clear that the Turkish response as a whole, in an attempt to make themselves more popular with Europe, engaged on very important and significant legal reform, leading to the creation of a constitutional court.
So I think, in all of this, and I'm afraid we're going to have to end here because we're going to run out of time, but in all of this, I think what strikes me is how Kevin Boyle was able to use the law to really try and remedy injustice. And it's a vision of law that I think is very important. And today, with human rights under threat in so many places, it's something that I think people can take away from to help sustain them as they continue to battle for human rights.
I totally agree. I think Kevin's legacy is to demonstrate that law is just not the study of black letter law in books. That law, when harnessed with action, can be a valuable instrument of social change. And in essence, through his teaching and through his activism, he has preached that message to generations of lawyers in many different countries, not just Northern Ireland and Ireland, but throughout Europe. And it is on those energies that we rely on to continue the work in these difficult times when human rights gets a bad name, but where the imperative of protecting human rights is just as important as ever.
Okay, we'll leave it there. Michael O'Boyle, thanks very much to all of you who've been watching and listening. I hope you found this as stimulating as I have, and I hope it will encourage you to go out and take a look at the book in which all of these cases and many others are dealt with in vivid detail. So everyone, thanks for your interest and stay safe out there.